Major breaking news this morning, the United States Supreme Court itself, that's right, the 9 justices heard oral argument in the United States versus Rahimi case. This is the case involving 18 U.S.C. 922 G8, which says that if you are a person subject to a domestic violence restraining order that meets the criteria of 922 G8, a federal gun control statute, then you are not allowed to possess firearms anywhere in the United States during the duration of that restraining order. This is a big deal here because this was the case that Joe Biden and Merrick Garland, the Attorney General of the United States, hoped and prayed would destroy the Bruen methodology and thus, by extension, our Second Amendment rights. I'm happy to report that I do not think this is going to work out the way Joe Biden and Merrick Garland had hoped it will. Stay tuned. We're going to break it down in great detail in 1 minute. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gunman, a constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans, and Israelis, by the way, about the importance of the right to bear arms. Check it out on audiobook as well as Kindle. All right, folks, top line. This morning, 9 Supreme Court justices filed into the court and heard the case of United States versus Rahimi, dealing whether or not the federal gun control statute, 18 U.S.C. 922 G8, is facially unconstitutional under the Second Amendment's right to keep and bear arms. The argument went on for about an hour and a half. 2 lawyers argued, the Solicitor General herself of the United States against Matthew Wright, the public defender, the federal public defender, on behalf of Mr. Rahimi. Just to jog your memory, Mr. Rahimi is the individual in Texas who was alleged and basically admitted in the form of a restraining order that he consented to engage in violent acts toward his then ex-girlfriend while he was subject to that domestic violence restraining order, which said specifically he was to give up his guns. He was found down the road possessing rifles and handguns in his home by the police, and thus he was in possession of handguns and rifles and firearms in violation of 18 U.S.C. 922 G8. The federal government indicted him and he was convicted. He asserted Second Amendment defenses, which really went nowhere until the U.S. Supreme Court decided in 2022 the Bruen decision that says that we have a right to carry guns outside the home and set forth in extreme detail the text first and historical analog laws methodology that was articulated first in Heller and then really laid out in greater detail in Bruen and expounded upon because the lower courts kept screwing up the Heller methodology of interpreting the Second Amendment. So they basically reiterated the Heller methodology in Bruen, except made it a lot easier for even people who couldn't figure out how to apply Heller could do so because the lower courts kept screwing this up, including by embracing improper interest balancing test of saying the good of guns versus the bad of guns in the context of Second Amendment cases, and the Supreme Court in Bruen says no can do. So what happened, as you know, is the Merrick Garland and Joe Biden do not like guns. They don't like the Second Amendment. And when the Fifth Circuit Court of Appeals down there in Louisiana and Texas found that 18 U.S.C. 922 G8 was unconstitutional under the Second Amendment by applying Bruen, with an extremely powerful concurrence by potentially future Supreme Court Justice James Ho. Only time will tell. We'll see how that plays out depending on who becomes the next president. The Fifth Circuit concluded that indeed, under the NYSERPA versus Bruen methodology, there was no analog gun control laws in 1791 that could justify the federal government, the Congress enacting 922 G8 that said was a blanket prohibition on firearm ownership or possession or use or any of this stuff while you were subject to a domestic violence restraining order. The Fifth Circuit said this was facially unconstitutional. Merrick Garland was salivating at the prospect of using this as the next Second Amendment case because Mr. Rahimi, frankly, on this court record, does not appear to be a very sympathetic character. He appears to be somewhat odious, and this was a good vehicle, so Merrick Garland thought, to gut the Second Amendment in Bruen. But as it turns out, after this hour and a half argument today, it does not appear as if the Department of Justice is going to get its wish. In fact, in many respects, I think the Department of Justice has just gone backwards in their attempts to destroy the Second Amendment in America. To begin with, let me tell you where I think this court is going to come out. I do think if you're Mr. Rahimi himself, this is not a good situation for you. You are likely going to lose this case. If you're Mr. Rahimi, you're probably going to lose this case. Could be 7-2, could be 8-1. Hard to say where Justice Thomas or Justice Alito come down. But the bottom line is no one on the Supreme Court seemed particularly bothered by the notion that 18 U.S.C. 922 G8 was facially unconstitutional because it seemed pretty clear almost from the beginning of the Department of Justice argument that if someone is a violent danger, they are violently dangerous, physically dangerous, then they can be disarmed. That seems to be the law at the time of the founding, and it seemed to be somewhat of a non-controversial proposition, which, by the way, is a very, very good proposition in the Second Amendment community, because, as you know, what Merrick Garland and the lefties want is they want to basically take guns away from all Americans and not just those that are actually physically, violently dangerous, like gangbangers and the like. They want to broaden the scope, which the Department of Justice tried to broaden the scope today at argument and in their briefs to say that anyone who's not responsible and anyone that's not law-abiding can have their guns taken away by the legislature. Do you hear what I just said? By the legislature. So basically, the Solicitor General for Merrick Garland was arguing robustly that anyone that's not responsible or not law-abiding can have their guns taken away by the legislature, really without any oversight by the courts. But it was pretty clear right from the get-go that the U.S. Supreme Court is not having any of that. The Solicitor General was asked promptly, wait a minute. Are you telling me that if I drive 30 miles per hour in a 25 mile per hour speed limit zone, that I'm somehow lose my gun rights? Or that I don't properly recycle? So as soon as those questions came out of the mouth of the Supreme Court justices to the Solicitor General of the United States, arguing on behalf of Merrick Garland, she basically retreated to the dangerousness proposition that if you are violently dangerous, we can disarm you, at which point one of the justices says, wait a minute, well, if that's your position, why didn't you just say so in your briefs? Why are you talking about these broad concepts of if you're going to be a responsible and a law-abiding gun owner, why didn't you just say so in the first place? And that's when she tried to say, well, it's up to Congress can define this stuff. And then she made, I think, a terrible mistake against the Department of Justice. And you bet your bottom, I don't want to say bet your bottom dollar, but you watch carefully. This is going to come back and bite them on the butt. As you know, there were two cases that were potential candidates to be the next Second Amendment case. One was the Rahimi case, which Merrick Garland pushed to the front. The other case was the case out of the Third Circuit Court of Appeals, and that was the Range versus Garland case. The Bryan Range case right now is up for certiorari. The reason why this is significant, in the Range case, that deals with a different part of 18 U.S.C. 922, prohibited people. That deals with those individuals who have been convicted of a felony. And in the context of Bryan Range, he has never been found to be violent, dangerous, anything of the like. He was found guilty of a misdemeanor that under federal law was deemed a felony because of the potential penalty associated with his conviction, even though he never spent a day in prison. And as a consequence, he lost his gun rights for life under 922G1, which deals with felons in possession. So what's interesting is that basically the Department of Justice tried to say that the way they see it is that if you are irresponsible, then you can be disarmed, a la Mr. Rahimi, before you are indicted or before you're criminally convicted. But if you're convicted of a crime, you can be disarmed under the theory that you are not law-abiding. So rather than what they did in their brief, which is to say that if you're not law-abiding or responsible, you can be disarmed. In the oral argument, as I see it, Department of Justice broke those down into two buckets, and those buckets are going to hurt them in 1 second. You'll see why. Because again, the two buckets are, she says, if you're not responsible, we can take away your gun rights without a criminal case, which is Mr. Rahimi, because keep in mind that the domestic violence restraining order that he was subject to in Texas was a civil case, a civil proceeding without any criminal things in and of itself. In contrast to, again, DOJ said today, if you're not law-abiding, then you can be disarmed effectively like a Mr. Range. Now, she did not mention Mr. Range by name, but guess what happened? And this is highly unusual. In fact, I'm not sure I've ever seen this happen before. Justice Amy Coney Barrett, during this colloquy and discussion about some of these topics, specifically made a comment about the Range case. Now, this is shocking in many respects because the Range case is not been granted cert yet. It's not before the court in that sense. It's before the court right now in that the request for certiorari to be granted is pending. But here's where DOJ made a terrible mistake in my mind from their point of view, which is that their entire argument, if you look at the briefing in the Range case, which we've covered on this channel before, their entire argument is don't take the Range case, which is very sympathetic for the Second Amendment movement because Mr. Range is really Jean Valjean in a sense that he is like, he basically, he didn't declare $500 in lawn mowing income on a food stamp application or something something like this, no evidence of violence whatsoever. So here's the kicker. DOJ says that Rahimi should be decided first by the Supreme Court and then range because they're very interrelated. However, today in oral argument, the Department of Justice just made a mistake of delinking those by saying that the Rahimi issues involving those that are not responsible is separate analyses from the range situation, is that you're not law-abiding. And by delinking them in this argument today, I suspect that when the Supreme Court on November 17th, has their conference about whether or not to grant cert in range, I think the argument to wait on range for Rahimi to be decided has just been dismantled by virtue of this major concession by the Department of Justice in this argument today. So I think that bodes well for the Second Amendment. The other thing to keep in mind is quite interesting, is it is pretty clear what the Department of Justice is trying to do here, which is exactly what I predicted on this channel, and anyone that watches the Four Boxes Diner will know what they were trying to do, which is they really hate the Bruen case. They hate the Bruen methodology, which, as you know, is not the Bruen methodology. It's really the Heller methodology that's been repackaged as the Bruen methodology. It's the same thing. You start with the text of the Second Amendment, and once the text of the Second Amendment is satisfied by virtue of how the individual wants to act, or the modern-day gun control law, the burden shifts to the government, and the government bears the burden at that point to come forth with showing historical analog laws to justify the modern-day gun control law, to show that the modern-day gun control law is not some newfangled thing. It's actually something that has been around since the beginning of our country, or the beginning of the Second Amendment in 1791. So what's interesting here are a couple things. First of all, there did not seem to be any real debate that Mr. Rahimi is part of the people, because if you remember, the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. In their briefing, the Department of Justice was trying to argue that Mr. Rahimi, by virtue of his illegal behavior, was no longer part of the people, and thus he could not exercise his right of the people to keep and bear arms. But it's pretty clear, based upon where this argument went today, that no one is buying into that argument. It's pretty clear to me that in this opinion that's going to be written, that Mr. Rahimi is going to be deemed part of the people, which is extremely good and the correct answer, because the words "the people" appear in the Second Amendment, yes, but the words "the people" appear also in the First Amendment and in the Fourth Amendment. So how is it possible? And we all know the Fourth Amendment is a criminal procedural issue that says that the people are not to be subject to unreasonable searches and seizures, or they're not to be subject to warrantless searches, all of which touches fingers with criminals often doing criminal things, exerting the exclusionary rule. So it's pretty clear that Mr. Rahimi, at a textual level of the Bruen analysis, will be deemed part of the people, which is good, because then the burden shifts. The burden shifts to the government, and what did the government do? And this is where it's very interesting. You can see this give and take between the Department of Justice by Merrick Garland and Joe Biden, the anti-gun crew. We're trying to work with the liberal anti-gun justices of Justice Kagan, Justice Sotomayor, and Justice Brown Jackson, because you could hear, I don't want to make a joke about, the old joke that says, would you like some cheese without wine? But to some degree, I would characterize that as exactly true when it comes to that, because one of the things, for example, Justice Brown Jackson was saying is, how can we possibly use founding era history when it wasn't even clear at the time of the founding that domestic violence was even considered violence, which of course is simply historically not true. The amicus briefs made it clear that at the time of the founding, 1791, domestic violence and beating wives and the like was totally verboten. You were totally not allowed to do that. I mean, keep in mind, we were founded by the Pilgrims, very religious people. So yeah, misbehaving like that was not allowed. Not only was it a problem as a matter of just religion and morality at the time of our founding, and they were very moral religious people, arguably even more so than today, right? Because everyone went to church in 1791. But beyond that, there was all sorts of criminal and related laws, including surety laws and affray laws and whatnot, where you could get into big trouble if you misbehaved. And the idea that domestic violence was considered not a big deal at the time of the founding is totally a myth, and that's been established by what's in these amicus briefs. But that's, of course, where Justice Brown Jackson was trying to go to. Then they're very upset, and I just want to remind you of one thing, why this is such a big deal. Then what the liberal justices were trying to argue is it's really unfair to modern-day gun controllers to force them to actually find regulations on the book. That's just not fair. And I want to remind you the context that this came up in. Remember that the way it works under Bruen and Heller. Under Heller and Bruen, again, once the text is met, the burden shifts to the government to do history. The question is, again, what type of history? And what's very interesting is exactly as I predicted. The liberal justices and the Department of Justice are trying desperately to get away from having to come forth with regulations to show that that is how you justify modern-day gun control laws, because the truth is there are very few gun control laws at the time of the founding, and it really upsets them that they have set this forth the standard. Now, there are gun control laws, and there are laws at the time of the founding. You had constitutions, federal constitutions, you had state constitutions, you had common law, you had statutes. So you had ample law at the time of the founding. It's just not the kind of law that the anti-gunners in the United States and the Supreme Court justices on the left like. And this is what they're rebelling against, because if you look at the language in Bruin, it says the following. And this is talking about applying the particular type of history, because remember, what the left wants and what the anti-gunners want is to apply airy-fairy history so they can bring Ivy League anti-gun historians into court and just tell stories, as I see it, about why, of course, the Founding Fathers would love it if they could ban guns, blah, blah, blah. But that's why the Supreme Court, saw down the chessboard and says, look, we want to see actual laws on the books. If there's no actual laws on the books, whether it be a constitution, common law, or statutory law, then it doesn't apply. And specifically, this is what they said in Bruin. Here's what it says. When a challenge regulation, quote, this is Bruin, when a challenge regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. Then it goes on to say, likewise, if earlier generations addressed the societal problem, but did so through materially different means, that also could be evidence that a modern regulation is unconstitutional. You see? So here you have in Bruin, the Supreme Court's like, if there's no law dealing with the social problem, well, that is evidence of a modern-day gun control law being unconstitutional. And the liberals are upset by this because this is too hard for government to meet. Because the truth is, our founding fathers expected everyone to carry firearms and to have firearms and to use them peaceably. That was the whole idea why we had in the text of the Second Amendment, the text of the Constitution, the right of the people to keep and bear arms. That was not a bug. That was a feature. That was a major part of our constitutional structure. And the left doesn't really like it. And that's why they're trying to say that any kind of history whatsoever that speaks to anything involving gun control law is a sufficient basis to justify modern-day gun control laws. But it's pretty clear that the U.S. Supreme Court right now is not buying that. All right, so to wrap up, the bottom line is I do not think Merrick Garland is going to get where he needs to get or where he wants to get. I think this is going to be a narrow decision by the U.S. Supreme Court that's just going to say 18 U.S.C. 922 G8 is facially constitutional. It's going to preserve all sorts of as-applied challenges for other people, whether it be the Commerce Clause, Due Process Clause, and other arguments involving, the Second Amendment and the like. But they're just going to say on the facial level, this is just simply not unconstitutional at this stage. And I think it's going to be a narrow decision. I don't think it's going to say a whole lot. And the one thing, thank God, I don't think it's going to do is going to repeal Bruin or do anything to open up the floodgates to more modern gun control laws. If anything, it may be backwards because, again, the Solicitor General made some really very troubling, from their point of view, and very good for our point of view, admissions and concessions that I think can be used in Second Amendment litigations down the road. So, all right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Don't forget to share and hit the like button. And don't forget to follow me on X at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.